If you die in Florida without a will, the state already has a plan for your estate. The question is whether you would agree with it. When a person dies without a valid will, they are said to have died intestate. In Florida, that means the state steps in and decides who inherits, based entirely on family relationships, not wishes. This process is governed by Florida Statute, Chapter 732, Part 1, beginning at Section 732.101. It's important to understand what intestate succession covers. It only applies to probate assets, things owned solely in the deceased person's name with no beneficiary designation and no co-owner. Life insurance, retirement accounts, joint bank accounts, and assets held in a trust are not affected. Intestate succession only controls what's left over. Florida's rules follow a strict family hierarchy. The surviving spouse comes first, but the amount the spouse receives depends on the family structure. If there are no children, the spouse inherits everything. If there are children and all of those children are also children of the surviving spouse, and the spouse has no other children from outside the relationship, the spouse still inherits. But the formula is different. The first $60,000 of the estate, plus half of everything remaining. The children split the other half. The $60,000 figure has not been updated in decades. On a $600,000 estate, for example, the spouse would receive $60,000 plus $270,000, a total of $330,000. The children would divide the remaining $270,000. If there are children who are not the surviving spouse's children, for example, children from a prior marriage, the spouse receives only half the estate. The other half goes to the children. If there is no surviving spouse, the estate goes entirely to the children, divided equally. If a child has already died but left their own children, those grandchildren step into their parents' share under Florida Statute Paragraph 732.104, a rule called per stirps distribution. If there are no descendants at all, no spouse, no children, no grandchildren. Florida Statute Paragraph 732.103 directs the estate to parents first, then siblings, then more distant relatives in a defined order. If no family member can be found at all, the estate ultimately escheats, meaning it passes, to the state of Florida under Proof 732.111. Half-siblings have the same inheritance rights as full siblings under Florida Statute Paragraph 732.105. Florida's $60,000 spousal preference in blended family intestate scenarios under Paragraph 732.102 has not been updated to reflect modern asset values. This is a well-known gap in Florida law, and one of the clearest reasons estate planning attorneys recommend a will for any married person with children from prior relationships. Florida's intestate succession laws tell you exactly what happens without a will, and for most families, a written plan of their own would look very different. Fade to channel logo.